Hi, everyone. I'm back. I was just finishing up talking about identifying who the client is. And we were using the example of a corporation and how there's real people behind the corporation, even though the client itself is the corporation. This, by the way, is a potential for a conflict because sometimes we represent the corporation. And in doing so, through our representation of the company, we have reason to speak with different employees who work there. And we just need to be careful that those employees understand that we're representing the corporation as a whole and not necessarily those employees in their individual capacity. That, if they might have a potential lawsuit or potential exposure to something, a potential liabilities due to their role in the corporation. And it's just a little red flag to kind of have in the back of your head when you're speaking to a corporate client to find out who the client is. Another one that could come up is if you have, let's say, spouses who are seeking a divorce come into your office together seeking representation because they feel like, hey, it's going to be an easy divorce. We don't have a lot of property together. We don't have children together. So can you just represent us both? And that sounds great because you get, oh, look, I'm going to have two clients right now. But clearly you can see that even in a best case scenario, that there's a potential for conflict. So that's another area where we need to think about who the client is, who we are representing. The other one to be aware of is if someone else other than the client who you are representing is offering to pay the legal bill, which can happen, and therefore maybe wants to sit in on meetings and be part of discussions. And as we've already alluded to this semester and we'll continue to talk about, the presence of a third party destroys the attorney-client privilege. So it's possible that you could be representing somebody whose the bill is being paid by, a family member or a friend, but that person is your client, not the one paying you. So just to be aware as we run these conflicts checks, to also keep in mind the ethical implications of knowing who our client is, because that's directly connected to these conflicts of interest. Okay, so we've done our checks. We know who this client is. We've run through the names through our system. Everybody at the firm has an opportunity to say, oh, we're representing the Smith Corporation. What if we find a potential conflict? Is this like an automatic, no? So we have options. If there's a potential for a conflict, one option is to disqualify your law firm from the representation. We often use the word recuse ourselves in the law. Sometimes, in the legal profession, we use this word recuse. Judges will recuse themselves from court cases where they have a potential for a conflict of interest. Let's say they know one of the parties to the case. So the judge recuses themselves, meaning takes themselves off the case. So the same thing can be true for a law firm. A law firm can turn to Smith Corporation and say, we cannot represent you because we have a potential conflict. We've represented an adverse party in the past, or we have another personal connection to your company or the legal matter. We can't represent you. Now, that's kind of unfortunate, right? Because you're probably thinking, well, there went a paying client. So there are a couple of other opportunities where you can keep the client, but you need to be really careful about how you do that. And that is why I linked for you here a court case to read about a paralegal's conflict of interest. And it was a rather long opinion, and I truncated it, I made it shorter for you guys. But it actually is a really interesting case to walk through and see how a law firm handled a conflict of interest when they found out that the paralegal had the conflict, and the steps that they took to keep the paralegal separate from the matter while they were undergoing that representation. So what you could do if there's a potential for a conflict is first seek informed consent. So you tell the party and you say, listen, here's the situation. We have a potential for conflict because of, and you name the matter. Here's what we will do to not allow our confidences to be compromised and not have divided loyalties. Do you consent to us representing you even with this conflict? But you can see where this is tricky because you just need to make sure when you speak with this potential client about this conflict that you're not exerting undue influence, something where they're being coerced into making this decision. So it really is an informed consent, an opportunity to say no and say, actually, I'm not comfortable with this conflict. I'm going to go look for another law firm. If the party provides their informed consent, what the law firm will do is build a Chinese wall. Clearly, the name comes from the Great Wall of China, the idea that you literally will put security measures around this matter so that others in the law firm or whoever has the conflict is kept separate from this material. And this is taken very seriously. As we mentioned on the last slide, in the last PowerPoint, we discuss our cases in the law, we have conversations in the hallways, we leave documents on a photocopy machine, we share files. And so there's a lot of potential for the confidential information to be out there and for someone to see it when it does not belong in their hands. So the steps that the law firm takes to build that Chinese wall can be scrutinized and need to be really extra careful just to make sure the client confidentials are not disclosed. So take a look and make sure you read the case that I've posted here because it really walks through what a conflict of interest looks like and how a law firm can handle it. Okay, so that's the end of the second PowerPoint about conflicts of interest and the systems, and I will end it here.